Right.
Okay. Okay, I'll just repeat that for the tape. So I know Michael Knudsen is not here for the June 12th, 2023 Planning and Zoning Commission meeting because he's out of town. Mary
Oh,
Ellen
wait, I
Dahlgren?
forgot to introduce us, so let me do that.
Okay.
Okay, good evening, ladies and gentlemen. I'm Michael Rossi, Chairman of the Clinton Planning and Zoning Commission. I would like to call this regular monthly meeting to order. Kathy, will you please call the roll?
Yes. So Mike Knudsen is not here. Mary Ellen Dahlgren? Okay. Eddie Alberino?
Present.
Mike Florio?
Here.
Martin Jaffe?
Here.
Alan Kravitz?
Here.
Adam Moore?
Here.
Cynthia, can you please tell me how to pronounce your name properly again? I don't want to mispronounce it. I'm sorry, you're on mute.
It's Chinzia.
I'm sorry. Thank you.
Just
Chinzia.
pretend like there's an H in between the
Gotcha.
C and the I. Yeah.
Okay. Chinzia Lettieri.
Yes, here.
Bo Clark. Not joined us yet. Jay Mandel.
Here.
Zach Plord. Not here. Okay.
And Zach's
So-
here. Zach's here.
Here.
Oh, okay. He didn't say he was here. Okay. All right. So the only people missing are Ellen, Mike Knudsen, and Bo may or may not be joining us.
Okay. For the time being, then we'll seat Jay for Mike Knudsen and Zach for Ellen Dahlgren.
Okay.
Okay, we have a quorum. So I'd like to start, let's see, minutes from the May 15th meeting. Did anyone have comments or corrections that they wish to make? If not, I would entertain a motion to accept the minutes.
I make a motion to accept the minutes.
I second the motion.
Thank you. Any discussion? All those in favor, please just say aye for this one. I don't think we need a roll
Aye.
call.
Aye.
Aye.
Opposed? Abstaining? Motion carries. Thank you. Okay. Next on the agenda is chairman's comments. I watched the video from last month and I don't want to, call anybody out or anything, but it just didn't seem like we were at our normal standard. So I'm hopeful this was just an aberration and will not be repeated. That said, this is a web-based meeting, so we're operating under following procedures. This session is being audio and video recorded. To ensure quality, the default rule for this meeting is that we ask everyone to remain muted. Commissioners and staff will generally remain muted except when speaking or voting, and will generally be keeping video of themselves on throughout the meeting. During the public hearing portion of the meeting, we're asking that you use the raise hand feature to signal that you would like to comment. That'll move you into the queue on my screen so I can call you in order. Applicants and member of the public should feel free to leave their video on or off. We will ask that you turn it on if you're speaking, but it is not required and you will not be precluded from speaking or providing public testimony. If a member of the public creates an audio or video disruption, they may be manually ejected from the meeting upon recommendation of the staff or chair, but I really don't want to use that nuclear option. Should you have any questions about meeting procedures or information discussed at tonight's meeting, please call the land use office during business hours at 860-669-6113. That concludes my comments. With that, we will move on to receipt of new applications. let's see. The first item for the receipt of applications is Planning and Zoning Commission 23-13, 23 West Main Street, change of use. It says new business, but it's really a change of use. Turning former medical office into tea lounge and retail, plus adding salt therapy rooms and basement. Interior renovations only, no exterior renovations needed. This is a site plan. Okay, it is not, so it does not have a public hearing. It is eligible for a decision later tonight after we receive it. Okay, so at this time, I would like a motion to receive Planning and Zoning 23-13 as a change of use.
And move to accept the application of PZC 2313.
Thank you.
I'll
Second,
second that.
Okay, I can't tell who got it. all
Eddie
at-
Alberino.
Okay, thank you. Any discussion? Okay. In that case, we'll do this with the roll call vote. All those in favor of receiving? Kathy, can you read the roll call?
Sure. Eddie Alberino,
Yes.
Mike Florio,
Yes.
Martin Jaffe,
Yes,
Alan Kravitz,
yes.
Adam Moore,
Yes,
Chinzia Lettieri,
Yes.
Jay Mandel,
Yes.
and Zach Lord.
Yes.
Okay,
Thank
unanimous.
you, everyone. Okay, our next item of business. I forgot to look at this. Yeah, our next item of business will be three sets of text amendments to the for zoning. All three of these are going to need to be scheduled for public hearing on July 10th. Okay, so the first one is Planning and Zoning Commission 23-14, proposed text amendments of section 14 vendors. Can I have a motion to receive and schedule for public hearing on July 10th?
So moved.
Second.
Second from Jay, thank you. Can we have a roll call vote on that, Kathy?
Sure. Eddie Alberino,
Yes.
Mike Florio,
Yes.
Martin Jaffe,
yes,
Alan Kravitz,
Yes.
Adam Moore,
Yes.
Chinzia Lettieri,
Yes.
Jay Mandel,
Yes.
Zach Lord.
Yes.
Thank you. The next one is Planning and Zoning Commission 23-15, proposed text amendments to section 27.2, non-residential schedule of uses. Again, we need a motion to receive and schedule for public hearing on July 10th.
So moved.
moved. Second it.
We'll take that, yeah, we got a first and a second there, that's good. Any discussion? Okay. Once again, Kathy,
You got it.
you're zipping
Um,
through the easy part.
Eddie Alberino,
Yes.
Mike Florio,
Yes.
Martin Jaffe,
yes,
Alan Kravitz,
Yes.
Adam Moore,
Yes.
Chinzia Lettieri,
Yes.
Jay Mandel,
Yes.
and Zach Lord.
Yes.
Thank you. And then the last thing we'll be receiving tonight is Planning and Zoning Commission 23-16, proposed text amendments for section 33, parking. Again, a motion please to receive and schedule for July 10th, public hearing.
So moved.
So moved.
Okay, so Mike and Eddie.
Okay.
Okay,
Eddie Alberino,
Yes.
Mike Florio,
Yes.
Martin Jaffe,
yes,
Alan Kravitz,
Yes.
Adam Moore,
Yes.
Chinzia Lettieri,
yes,
Jay Mandel,
Yes.
and Zach Plord.
Yes.
Okay, thank you.
thank you, everybody. Now we get to where we do the real business. We had public hearings we have public hearings scheduled for 3 text amendments today. So the first one is Planning and Zoning Commission 8, proposed amendments of Section 5, zoning enforcement officer. We have for this both the draft regulation as well as both the markup and the clean version. And then we have a review memo from Abby, which is really very simple here for zoning enforcement officer. The change was recommended by staff to clarify that the Connecticut River Health District will review proposed changes to lot lines. So even though the thing's called zoning enforcement officer, that's what it is. New language codifies existing practice and makes it known to owners and professionals who may be modifying boundaries that compliance with health code requirements will be reviewed. Were there any comments or concerns about the changes to Section 5 from the commission before I open this up to the public? Hearing none. Is there anyone from the public who would like to speak in favor of or in opposition to or just general comments on this change in the regulations? Okay, hearing none. I would, and since there were no comments from the commission, I would entertain a motion to accept these changes with an effective date of August 1st. Okay, to give time for any review.
So moved.
Okay, thank you, Mike. Do we have a second? Alan? Thank you.
I did, sorry.
Okay.
We're fine.
Eddie Alberino,
Yes.
Mike Florio,
Yes.
Martin Jaffe,
yes,
Alan Kravitz,
Yes.
Adam Moore,
Yes.
Chinzia Lettieri,
yes,
Jay Mandel,
Yes.
and Zach Plord.
Yes.
Okay, unanimous.
Thank you. Next is the public hearing for the proposed text amendments to Section 4, application requirements, procedures, and design process. Again, we have both the clean copy and the markup that were distributed. And we have the memo from Abby again for this, which is very short and short and sweet. The main thing that was going on here is that it's switching over to recognize that we're using online application procedures, so that, you know, number of paper copies and stuff like that are not necessary. And also to correct some cross-referencing to other sections. Okay, so this is all fairly straightforward. Is there any comments from any discussion from the members of the commission? Hearing none, I will open this up for the public comment. Is anyone here from the public who would like to comment on these text changes? I'm quite pleased that we picked the easy ones first. Okay. With that, can I have a motion to approve the changes in section 4 for Planning and Zoning Commission 23-9 proposed text amendments of section 4 with an
So
effective
moved.
date of August 1st?
So moved.
Thank
I'll
you.
second.
Thank you, Eddie. Okay,
Okay. Roll
go
call.
ahead and do the roll call
Um,
vote.
Eddie Alberino,
Yes.
Mike Florio,
Yes.
Martin Jaffe,
yes,
Alan Kravitz,
Yes.
Adam Moore,
Yes.
Chinzia Lettieri,
Yes.
Jay Mandel,
Yes.
and Zach Lord.
Yes.
Great. Thank you. Unanimous.
Thank you. Okay, our next item is Planning and Zoning 23-10, proposed section 3 regulation amendments. This is in the definitions section. Several definitions that were in 27 before have been moved over, but ones that might want some discussion, we've got dwelling unit, accommodations for transient lodging in a bed and breakfast, hotel, or motel shall not be considered a dwelling unit. And then the other one that might is the definition of family. And this is changed so the words "an entire" are dropped from the definition. Did anybody on the commission have questions, comments, concerns on these? Okay. And in that case, I will open it up to the public. Is anyone from the public want to talk about the definitions? Okay, hearing none. I will then entertain a motion to approve section 3 with an effective date of August 1st.
So moved.
Thank you, Mike.
second,
I'll
Second.
second.
Thank you, Martin.
Okay.
Okay,
Eddie Alberino,
Yes.
Mike Florio,
Yes.
Martin Jaffe,
yes,
Alan Kravitz,
Yes.
Adam Moore,
Yes.
Chinzia Lettieri,
Yes.
Jay Mandel,
Yes.
and Zach Lord.
Yes.
Great. Unanimous. Thank you.
okay. Now I just did what is next is we approved those.
Yes.
So
Right, you essentially combined those two sections of the
Yes.
agenda, but the action, the result is the same.
yes, so we've jumped through 6A, B, and C. We're now at Planning and Zoning Commission 2313 for 23 West Main Street, the change of use. Again, this is a site plan. So this is turning a former medical office into a tea lounge and retail on the first floor, plus adding a salt therapy room in the basement. It's interior renovations only with no exterior renovations needed. Was there any correspondence? I didn't see anything. Kathy, do you know?
No, I mean, we haven't had any, I can go through the list, but as you said, since I don't think anyone's here representing the applicant.
Is Christine, is that our applicant? Excuse me.
I think, is Christine here for the 11 Lindera Lane?
Oh,
Yes.
never mind. Okay, sorry.
Yeah.
So, okay, yeah, no, I don't see an applicant. So that may be a reason to potentially continue if they're not here to present. That's up to the commission. Basically in the staff memo, we tried to lay out which were the applicable regulations. In particular on this site, the parking issue is the most sort of out of the ordinary, because the parking, predominantly the parking for this particular site falls off of the property itself. However, I tried to lay out for you the various elements that would enable you to waive those particular requirements. And so in this case, because of the relative straightforwardness of the application, we provided a recommended motion. How you choose to move with that is yours. But I don't believe we've heard anything from the applicant today.
No.
Well, Mr. Chair, point of order, I'd like to make
Go
a
ahead.
motion. I'd like to postpone this because we can't ask any questions and they can't
Okay.
elaborate on what they're, exactly
anyone
what they
there?
want to do. So we'll make it to next month.
Ed?
Okay.
Yeah, I'm here.
Oh, I'm sorry.
Yeah.
Did you look
So
past
I-
Christine, my wife, or was this something different?
No, we just were looking to see if anyone was here to represent 23 West Main Street, and we saw
Oh,
your
I'm
name.
sorry, totally
And just
different.
were wondering if it was the applicant, and I remembered you were here for the next item. So
Yeah.
you're all
Okay.
set till we move
And
on.
I agree with you, Eddie, that without the applicant, I would prefer to give them a chance to address this. So
Okay.
I
Thank you,
would
Mr.
entertain a motion to table this application for this month.
Yes, till next month. Yes, sir.
Do I have a second?
I second.
Thank you, Jay. Okay.
Okay.
There is no discussion on a motion to table, so can you just do the roll call?
Sure. Eddie Alberino,
Aye.
Mike Florio,
Aye.
Martin Jaffe,
Aye.
Alan Kravitz,
Aye.
Adam Moore,
Aye.
Chinzia Latieri,
Aye.
Jay Mandel,
Aye.
and Zach Plord.
Aye.
Okay, unanimous.
Okay,
Thank you.
so now we're on to item 7. Administrative review 11 Lindaria Lane. Discussion of the conservation easement and wetlands boundary. Is there an agent or applicant that wanted to present this to us and give us any new information?
Yes. My attorney Ed is with a client, so he's supposed to be coming on very soon.
Sir, can you just state your name for the record, please?
My name is Andrew Randy. I live at Lindera Lane, 11 Lindera Lane.
Okay, thank you.
Okay. Let's see. While we're waiting for Ed to get here, as promised last month, Abby did prepare a document that went through all the records in town and explained what we had and didn't have on record. It's a fairly complete, well, it looks absolutely complete in my view.
If I may say
Starting with the
something,
Hooper's Landing Phase 2 subdivision approval and going through everything that they could find in the records.
excuse me,
Yes,
can I say something? I'm sorry to interrupt, but for the record, the documents and the pertinent information is not complete. There's multiple documents that are missing from this. And I think that's
the
what,
documents are not in the town record though.
yes, they are. Because I got and retrieved those records from the town.
Okay, can you present those to us?
Well, I gave a packet to Abby about 2 months ago.
Yeah, and most of that
Hi, this
information
is Ed Casella.
Oh, hi. Okay.
Ed Casellas here. Can you hear me okay?
Yes.
Yeah.
Okay, thank you. I'm just, I'm trying to get logged on here, but if you can give me 1 minute, I can, I can start addressing the commission. So hold
Okay,
on
thank you,
one
Ed.
second. No problem, Mike. Thank you. Jumping in between meetings here, so you got to bear with me a little bit if you don't mind. All right, so I just want to, we spent a decent amount of time at the last meeting talking about the history of what happened and what we're actually requesting. But just to summarize, the Randys purchased lot 11 which is part of the Cornerstone subdivision. The subdivision was originally approved in 2002. For economic reasons, which we're all aware of, a lot of the construction on that development didn't begin in earnest until later on in the decade. Their house was started in 2009 and completed shortly thereafter. What we're requesting is to modify a 2002 conservation easement that was imposed by the Planning and Zoning Commission as part of the original subdivision approval. And as we explained previously, we had met pretty substantially with Tom Lane after the Randys purchased the property in 2012 and had more or less agreed with him to this modification. And we understand today that process wasn't, for lack of a better term, a complete process. And so now we're here asking for the process to be perfected and completed. So specifically, as Mr. Randy was just talking about, and I'm sorry, I'm on the move, so you got to just bear with me, but I'm trying to go as fast as I can.
You're muted, Ed.
Yeah, I know. I figured you didn't want to hear what I was just doing. So the town records regarding this property, I think everybody would agree, are really lacking. And what we're asking the commission to do is basically modify what we agreed to modify what we had agreed with Town Lane back in 2012. It's interesting. We read Abby's report, and one of the takeaways from that report is that you have the discretion to be able to do what we're asking you to do. I think it's the right thing to do given the facts and the history. And I also think that this is a very unique set of circumstances. This isn't the type of situation that's going to happen, again, more or less. So when we're asking you to modify a conservation easement, it's based on this very specific set of facts. In the record, in Abby's memo, you'll note that we applied and asked permission from the Red Wing Foundation to modify this easement, and they agreed that the modification was acceptable to them. So planning and zoning allows the modification to proceed. The final step would then be to go to the town council because the original conservation easement was in favor of 3 parties: the Planning and Zoning Commission, the Red Wing Foundation, and the town of Clinton. So all 3 of those entities need to sign on. I want to make 3 points, and this will get into what Andrew was just talking about. And I think even in Abby's memo, it's apparent. We had a whole process with Tom Lane in 2012 where we met with him out on the site, provided with him copies of our proposed modification. He agreed to the modification, and we recorded the modified conservation easement and the updated map on the land records. Apparently, the same thing happened in 2009 before the Randys purchased the property, because there's a map filed. It's a septic map, proposed septic plan that says, oh, the conservation easement has been modified by Tom Lane. And that's just a note on the map in his file on the land records. And unfortunately, the file at the town of Clinton has no records about either of those events occurring. So this isn't an isolated incident. Basically, what happened with Cornerstone development of the property, they got approved in 2002. There should have been a full 50-foot conservation easement off of all of the wetlands. Instead, when they started developing, they filled as far as they wanted to in violation of the recorded conservation easement, and then set up rock walls. You know, if you look out there, and I'll show you a picture in a second, they set up rock walls to delineate the edge of lawn, the edge of fill. The original conservation easement requires that existing vegetation remain. So that was what the practice was in 2009 and 10. And when you look at the maps that Abby provided regarding the 2009 modification, they built the driveway within the 50-foot conservation easement. They filled along the side within the 50-foot conservation easement, and they built about 30 plus extra feet of lawn within the 50-foot conservation easement. So when Randy's purchased, they purchased thinking there was not understanding that there was a 50-foot conservation easement, which basically limited their backyard to 20 feet. The entirety of their backyard well exceeds 20 feet, but under the conservation easement, they didn't realize that. And there's no real, unfortunately, the as-built that was provided for zoning compliance doesn't show the conservation easement line after the house was built. It only shows the septic, doesn't even show the wetlands. So that's part of the problem here, is there just was a lack of information. After the Randys purchased, they realized that the developer overbuilt their site and was in the process of overdeveloping a number of other lots. And this led them to work with Tom Lane, and he issued notices of violations for the developer who was continuing the same practice. So again, back to kind of the central theme, which is, what we're asking the commission to do is to modify the conservation easement in line with the 2012 modification of conservation easement that was approved by Tom Lane. And then we have to go to P&Z. So hold on one second. I'm switching devices here. I'm going to put you on mute first. Abby, can you let me in? There you go. All right, I'm coming. Okay, I'm back. Oh. Now I'm just on my computer.
Okay.
Thank you all. Whew. That was tough, but I didn't want to keep you guys waiting, so I appreciate your consideration. So let me show you exactly what we're talking about here with the lines. I'm going as fast as I can, I promise.
So Ed, while you're
Yeah.
pulling that up, how far into the conservation easement are you asking to go?
It varies. I'll pull this up here. And I believe if the commission has in their possession, the attachment from 2012, number 5, I believe is the one. Yeah, this is. So this is the plan that we presented to and was approved by Tom Lane in 2012. So Lindera Lane, here's the street. Here's the driveway that was constructed. Here's the house, septic's in the front. The wetlands are on the south, on the north side of the, whatever this is, the west side of the property, and then come along and there's another patch of wetlands over in this area here. So the 50-foot conservation easement that's in effect comes across here, cuts through 2/3 of the backyard, cuts through where the driveway went, and extends out. So we're asking for the conservation easement to be pushed back to this line here, this is all based upon as-built developed property. And then along where the rock wall is the closer line. And then in between is kind of a maintenance buffer where the Randys can maintain the vegetation that's on their property currently, which consists of a number of trees and other landscaping. So there's the modified conservation easement goes into the rear, and the maintenance buffer is an additional 10 feet just to protect the wetland. But again, the purpose of this is just to memorialize what was built on the site, what was approved, and what was as built in. So here's the aerial photograph of the property. And you can see this rock wall is what Cornerstone did. They would come develop a site and they would use a rock wall to kind of delineate between the yard and going down into the wetlands. Remember, the 50-foot conservation that was approved in 2002 was here. So any activity beyond here was illegal. You could see that pattern is same thing over here on this property. On the north property, you can see the rock walls used again to delineate between fill, lawn, rock wall, wetlands. So that's what Cornerstone did, and that's what the Randys purchased, thinking they had the right to have a normal yard like we all want in the back of their house. So when they found out that this wasn't the case and that this practice was continuing from 2009, 10, 11, 12, that's when they got upset and this whole thing blew up. And during those discussions, Tom Lane understood that he allowed this to move forward. So he wanted to make it right and allow the Randys the ability to use, their backyard and their property. Yes, there was a modification to a 40-foot easement because the driveway was clearly within, the driveway was within the 50-foot. He approved that without going to any commission. So we did the same thing. And now we're here. There's no records at all in the town about any of this. And asking the commission to hopefully do the right thing. And one other fact that we have is in 2013, the Randys applied for a permit to develop their backyard as shown here within the 50-foot conservation, but outside of our conservation, to put a generator in, stone walls, retaining walls, and a playscape in the rear, paver patio. And Tom Lane signed off on that. And when he signed off on it, here's the sign off: retaining wall, generator, playscape, site plan, see attached. Erosion controls, and you can't see this?
Can see it.
You can see it?
Yep.
September 2013. A year after we filed the modification, and it's got the new plan. It's got the new plan shown here with the modified conservation. And this is the plan coming all the way back: generator, pavers, flower box, Belgian block. So, thank you for your patience through this evening tonight, but that's the sum and substance of why we're asking the commission to assist us, make this right, modify the conservation easement as was agreed with Tom Lane, so that we can finally have, a clear understanding. We have a map. We're going to have a new conservation easement that mirrors the previous conservation easement, that continues to protect the wetlands, but allows the Randys to utilize their property as it was as built, and the CO was signed off on.
Okay, I have a couple questions and concerns since I've been here since that subdivision was approved. First of all, just to be, absolutely clear here, this subdivision would not have been approved without that conservation easement. That was an essential point of discussion. So, without that easement, we wouldn't have had any housing here. And this property, the house that, originally shown was not that far back. It was the building square was towards the front. Okay. So, and then the other concern that I have that's very strong one is that Tom Lane had no authority to do that.
Yes.
Okay. This had to come to us.
Right.
Okay. Changing a deed restriction is not something that can be done administratively.
No.
It needs to come to the commission, as you're doing now. Okay. So the other concern I have from what you said is that this wouldn't apply to other properties, but you've just shown us that there are several other properties all along this side of the street that this would necessarily apply to. So how are we going to make sure that what we do here is fair to everyone and not just give away protection to land that went through multiple public hearings, very contentious public hearings? People did not want this to go in. Okay. So that easement is what made it possible for the subdivision in the first place. So you got to be very careful how you're going to word any exception if we're going to be considering changing the easement. And I'll get to you, Cynthia. I want to let Ed, respond, because I know I just threw a lot at you. I apologize.
No, that's okay. Well, I think there's two things on this property that, like I said, make it unique. First, we have the map that was re-recorded in 2009 that shows a modified conservation easement approved by Tom Lane. And we have an actual updated conservation easement that was and map that were both recorded in 2012. So I endeavor to say, I haven't searched the properties, but I endeavor to say no other lot on this in this subdivision has those two things, right? So there was a history here with this lot that doesn't exist with any other lot. As far as, really, the problem here was the house in this location. The reason it was pushed back was probably because of septic, right after the approval. And once it got all pushed back, it got pushed substantially into the conservation area. So that makes this property alone stand out. So I think the commission can use that in its decision.
Thank you. Cynthia?
I just had a clarifying question. So you said that when the property owners, when the developer was building on the site, Cornerstone, they were not adhering to the wetlands easement to begin with when they started building these properties. And then the owners figured out that they were developing other properties and were also not adhering to what the property easements were. Is that correct?
Yeah.
So they were already doing something that they shouldn't have been doing. They were already taking parts of the wetlands that they shouldn't have been taking. So essentially, when they bought the house, they got land to use that they shouldn't have because the developers were doing something illegal.
Well, it's nothing's into the wetlands. It's all about into the upland buffer, right?
Correct, but it's still
Into the
property that
conservation easement.
it's still part of that conservation easement that
Correct.
they should not have used, that the owners of these properties now have because somebody decided to not listen to, the conservation easement.
Well,
Is
they
that
didn't
correct?
follow-
that's really what the rub is here, right? And that's why Tom Lane did what he did, is because the Randys paid a significant amount of money for a piece of property that was fully signed off on by the town that shouldn't have been. And now there's violations. So they didn't buy what they thought they were buying, right? And so Tom Lane was like, oh man, I screwed up because I didn't ask for an as-built of the condition of the improved lawn. How far into the wetlands does the improved filled lawn go? These guys buy based on site, right? There's no as-built that actually shows how far that lawn goes into the conservation area. So that's what the original problem was that caused this big uproar in 2012. And hence we reached the resolution, like, you can keep what you have and now we'll protect this area.
Thank you. We have Mike, then Abby, and then I know Adam had his hand up, and then Alan. So go ahead, Mike.
I don't know if you guys know, but I do live in this development on Lindera Lane. I was actually one of the first houses being built here. I built it myself because that's what I do. And I just want to let you know that some of the stuff that went on here was unbelievable, unconscionable. First, my dealings was they had said that they dug test pits for my septic system, where my septic system had to go. Greg Fettis designed it. We had everything delivered. The contractor went to go put it in. Unfortunately, there was rocks there. It was impossible for them to have done test pits where they said they were going to do them. So I had to send everything back. I had to sue Shelley Mankiewicz, and then I had to redesign my whole septic system. There was so much corruption going on in this neighborhood. You guys wouldn't believe it. My neighbor down the street, her septic was actually put in the wetlands. And until all of this started happening, they made them move it. I mean, there was a lot of things that happened here that you can't even imagine, just stuff that was lies, really. They were filling in stuff and making people believe the fact that part of their backyard was part of their backyard, but it really wasn't. So this whole thing was a mess.
Thank you. Abby,
So I certainly, I recognize that the record that we have available to us through the town land use office is spotty on this topic. And so I think that's important to acknowledge. But the land records do have a substantial amount of information, and then which I try to summarize in the memo. One thing I think is important to note that Tom Lane isn't here to defend or talk about what did or didn't happen. And so I know there are folks in the room who have a recollection, but that doesn't necessarily translate into an approval or action that he didn't or didn't take on the record. And that's one of the reasons that it's been difficult for staff, when Mr. Randy first came in to say, hey, Kathy, can you help us sign off on this pool application, or where we want to go with moving forward on potential use of this yard area. There simply wasn't a record of any kind of required approvals to be able to do it. So things can be filed on the land records without actually coming to our office at all. So it's important to note that lots of different things can get on there. The 2009 reference to Tom Lane's approval on that 2009 septic plan. It's not actually endorsed by Tom, where many of the subdivisions and certainly the Hubert's Landing Phase 2 subdivision was endorsed by Tom on those various pages in the land record. So there is a little bit of a difference between when a zoning official signs off and when there's what that record looks like. And typically there's a place for them to sign or something in writing. Now I know that this is a difficult one for those records, so I won't go too far into sort of that spottiness. A couple of things just to point out, that 2013 approval for the generator, the playscape and those improvements, the zoning permit that was granted were for those things, right? Specifically, not an endorsement of the underlying plan. We've been through this with the town attorney a couple of times, and she's been very clear with us as well, that the work was approved, but a modification to the conservation easement or a proposal for a future pool was not approved as a function of that administrative zoning approval. So I wanted to just make sure that the commission was clear on that part of that. So if the commission is amenable to a modification right now, the process beyond going through this commission and town council would then be an application to the Inland Wetlands Commission for any future pieces in that area, because even without the conservation easement, it's still within the upland review area for wetlands. So I just want to sort of clarify that part of things. If and again, whatever did or did not go on between homeowners and the construction company and the zoning official at the time, the reality was the zoning official did not have the authority to go forward. And so the path here is whether or not this commission is comfortable modifying the easement based on existing conditions or not. And the only thing that I would recommend that is, if the commission intends to make a recommendation or to go forward and recommend to town council that this be finalized in the form that Attorney Casella is noting, that there's very, very specific findings as to why this is approvable, because conservation easements aren't meant to be modified. They are meant to run with the land. And so I think there certainly should be something very specific that doesn't set a precedent, that this is something that other folks can come in and ask for modifications as a routine kind of thing. And I think we need to note the special nature and very different characteristic of what's going on here. The last thing I would say is that if there is conversation, in the next pieces of this discussion that move forward, I would ask that any easement language and final mapping be approved to the town attorney as to form if it does go forward, and have that be a recommendation out of this commission if you do intend to proceed.
okay, thank you. I believe, was it Alan next or Adam? I don't,
It was
Adam,
on.
okay,
So clearly, this is not a black and white situation. And based on Mike Florio's testimony, it's more rampant than just 11 Lindera Lane. As commission members, we're charged with having the discretion to deal with these black and white situations for what's in the best interest of the town and its property owners. There's no doubt in my mind that the town was complicit in the approvals. back then. And while Tom Lane may not have had the authority to do this, he certainly was acting on behalf of the town. And, you know, it's my opinion that we have the opportunity to potentially fix something here. And we do this all the time. We take non-conforming pre-existing conditions and bring them into conformance. And I think that this is probably one of those situations, and especially given that the Red Wing Foundation takes no exception to this. I think it's my opinion that we and I know there's more discussion to come, but it's my opinion that I would want Attorney Cassell to work with the town attorney to craft the appropriate language to bring this to the town council.
Okay, thank you. Alan?
Yeah, I have a question. Where did the titles fit in this? What did the titles match? They bought something that should be clarified in the title, and there's been innumerable title searches in that property on the and abutting properties. So what's
I
the
could-
status of titles?
I-
Ed probably can.
I could speak to that. Right now, the title is a little murky because it has a 50-foot and a modified 40-foot conservation easement and the third conservation easement that we filed in 2012. So what would I assume this would be part of what we would clarify with the town attorney is probably coming up with language in hopefully a new conservation easement that basically describes everything that's happened in the past and sets out that the new standard is this, you know, what we agree on. So that's the way that the title would be handled, because right now the title's a little bit of a mess.
Yeah.
Okay. Thank you. Mike Florio, you're back.
Yeah. I agree with exactly what Adam said. I mean, I think that Tom Lane was acting on behalf of the town and gave them permission to do what he did. Regardless if he had the authority to do it or not, he was acting as he did. So how would anybody not know whether he had the authority or not at the time?
He's a real estate lawyer.
Well, I mean, he was acting on the behalf of the town and he told the Randys what they needed to do, and they did it. And now, unfortunately, if Mr. Randy put the pool in 10 years ago, we wouldn't be having this conversation. I mean, the pool would be in, right? Because according to Tom, that's what he approved.
That's.
I know it may not be right, but that's what it would be.
But the pool wasn't on the approval. It was the other things, the generator and everything, not the pool. The pool was
But
never
on the
on the
drawing-
approval language.
Right. But the other thing too is if you look at the drawing where the original 50-foot conservation easement is, that is literally 15 feet off the foundation. If they didn't clear that back and put that rock wall in to give them the illusion, or anybody that bought that house, the illusion that their backyard was bigger than what it was, no one would ever buy that house. Who would buy a house with a 15-foot backyard? So they filled that all in, put the rock wall in, and basically we're telling people, this is your backyard. So how would anybody not know that they couldn't use 15 feet past their foundation?
Title search.
Ed,
Yeah.
you're next. Oh, you're muted, Ed.
You're muted, Ed. Ed, you're muted.
Mike, could I say something after Ed?
I'm
Who was
sorry.
that I missed?
Okay.
I agree with everything Adam said, and they have a brand new conservation easement signed by Red Wing. Is that the name, Ed Casella at Red Wing?
Red Wing Foundation.
Yep, they signed. So they have no problems with their thing. And also Tom Lane acted in the capacity of the wetlands enforcement and zoning enforcement officer. So he should take the bite for this. The town should.
Well, again, we can't,
But he did.
he's
Bill,
not
you
here
might-
to defend himself.
Okay,
Just
okay,
stay
but
to the
he-
facts.
I was stating the fact, he signed off on this. You've seen the signatures, he signed off as a representative of the town, and as Mike Florio said, who would buy a house with a 15-foot yard? I mean, I think we should just do the right thing here and let them have that property. That's my opinion.
Let's see,
Thank you
who
for
was
letting me
next?
speak.
I like to
Andy?
speak.
Jay,
Jay,
Jay Mandel.
Yeah, thank you, Mr. Chairman. So my understanding, the big picture is these homeowners want a pool in their backyard, and now they find they have no backyard, right? Basically, that's what's happening.
Right.
I think and that's the way I interpret it. So the question is, to me or to the town, is there any way to give their request approval without setting a precedent to other property owners in this area in the future? Is there any way to doing that? That's my question.
Yeah.
I mean,
Go ahead,
If I can, through you,
Abby.
Michael.
Go ahead, Abby.
So the key here would be to make very specific findings, very property specific findings, so that the commission would need to recognize that there are particular conditions at 11 Lindera that are of such proximity to or encroach into the 50-foot easement as it was originally recorded, and even into the proposed modifications, even if they weren't done with the correct approval process, that the existing conditions already constitute an encroachment. So there's sort of a two-part piece here. You would need to find that that the proposed line that they're looking at is consistent with existing conditions, that it is specific to this property, that this house was perhaps built farther back than others. I think there would need to be some particular set of circumstances that I believe Attorney Casella would need to lay out, and you would need to sort of find that says this is unique. This is not a normal circumstance, and that that there is no intention to modify for any other property through this action the original boundary. So I think you would want to make that very, very clear on the record. It's not to say that somebody else couldn't come in and come up with their own research, and if there's other property owners in the neighborhood who have similar concerns, we haven't heard from them. That doesn't mean that they don't exist. But I think that's important to talk about. The other thing is too, if there are things allowed or disallowed in that maintenance area that they've discussed from the 2012 proposal, I think that's important to discuss what the commission would and wouldn't be comfortable with in that space. So that's another thing that might make sense here. I don't think you can protect against anybody coming forward with a similar request in the future. I think what you can do is try to make the findings relative to a potential approval here as specific as you can.
Thank you. Cynthia, did you have your hand up still, or okay?
I just want clarification on what was included in the 2013 permit from the owner or the Attorney Casella. So you would ask for a playscape, a generator. These are all the things that got apparently signed off by Time Lane, even though he did not have the authority. Was a pool included in that in 2013?
No,
Okay.
The pool wasn't. Oh, finish your question.
Yeah, I was just wondering when did the pool come up?
Yeah, so I can answer that. And I'm sure the Randys could as well, but the desire at that point was to improve their property, including that portion of the backyard, and to obtain permission for a pool. They had very young children at that time, and due to safety concerns with having really young children, did not want to move forward with the pool at that time. And it's only been more recently where that they started contacting the town, Abby and Kathy, and that's frankly why we're here today. So the pool will need a inland wetlands approval as well. So even there's multiple layers of permitting here. the obviously modification of the conservation easement, but then there'll also need to be an inland wetlands permit issued for the pool as well.
Okay, but you did get the
If I
playscape.
can just make one point, the point, you know, we're talking about what Tom Lane did or didn't do and what facts there are. And the point is, the driveway was built inside the 50-foot conservation zone. So he authorized a reduction of the conservation to 40 feet, right? I think we can all draw that conclusion. The property was filled to 10 feet off of the wetlands at its closest point. And therefore he authorized the, you know, them to have their backyard. I think that again is a fair conclusion to draw without casting unnecessary dispersions on, you know, Mr. Lane. That's what the documentation provides. The fact that the reason we bring in the permit, he signed a permit using the plan that he knew about in 2012 and signed off on, right? Like you can draw that conclusion. It just further, we hope the commission sees that it just further supports the fact that these discussions were all had. He met us on the property. We went through all this and this was all agreed to. That's the point here. Would he have signed off on a 2013 permit that showed that map with the new line? No, of course he wouldn't have. Not unless everything that we're saying happened in 2012.
What,
So-
can I just,
Yep.
attorney, because I think just with all due respect, I think it proves that this owner was lied to over and over again. I think that's what, you know, or did things that he was
and you know,
not
that's,
authorized. But aside from that, I just kind of want to, a couple other questions. Did you do any type of research on any potential impact to the wildlife, to the wetlands? If we decide to take even more of an easement that shouldn't have been taken from the beginning? And is there
no.
any impact report on what potential harms giving up more of the wetlands that the town obviously fought hard for to conserve?
Well, again, remember, there's no encroachment into the actual wetland. This is a matter about how far it's being encroached into the upland review area. And the lawn is already there, right? It's already been improved. It's been in this condition for 13 years. So now the question is, can they have a pool which requires another level of inland wetland permitting? That they'll decide.
And do you have any specific set of circumstances like the town planner has asked for particular conditions that exist for this property?
Yeah. I think when we finish this discussion, I'd be happy to provide that, but I'm interested to hear what other questions and comments.
Okay, Alan?
Yeah, I don't go back where I was before. The question of title is important, I think. What does the title reflect about the easement? Because there's an easement involved in the title. What does the title say? And this is going to be we know from our own membership that it's other units were affected by whatever caused the mismatch of the development with the permitted development.
I think I answered this question before. Right now, if I gave you a title review of the Randy property, it would say subject to a 50-foot conservation easement, subject to a 40-foot conservation easement modified as shown on the septic plan, and subject to the 2012 declaration of perpetual conservation restriction easement, which showed the two maintenance area and conservation easement. That's what the title would show.
And I think, Alan, the deed in 2010, which is attachment 4 in the memo that I provided, the property was conveyed to the current owners with subject to the notes and conditions from Hooper's Landing Phase 2, which included the 50-foot easement is shown adjacent to all wetlands, including lot 11, the original declaration of conservation restrictions from 2002. And it did reference the modified conservation area shown in the 2009 septic plan. So it was conveyed with those pieces. And then subsequent to that, as Attorney Casella said, the two 2012 elements came on. Is that
Yes.
helpful?
I have a question.
Go ahead, Martin.
Could they build the pool with a 40-foot setback?
No.
Well, I mean, they were put on notice of I'm with Alan. I mean, the title of the property tells what they can and cannot do, and the fact that the code enforcement officer messed up, they were put on notice. They got to do due diligence when you purchase property. They knew what they were entitled to do at the time they acquired the property. To a large extent. And even assuming, that the person had authority back then, or you view them with authority, they still wouldn't be able to do what they wanted to do. I mean, even assuming that the line was adjusted, they still can't build a swimming pool. So, I'm not too sympathetic to people who don't read their own deeds. I'm sorry.
If I could make one response to that, the problem is there's no map that, seeing a 50-foot conservation easement doesn't give you any, when you're on a property, you don't know where that starts and ends, right? So it's just on a map, and then the Randys are standing there with a real estate agent. Their attorney's never been to the property. Their attorney who did the closing looks at the title. He's never been to the property. He doesn't know where the line is.
You
So
should sue the developer and sue the attorney.
well, that's great. That's a great solution, but we can't do that 13 years later. We thought we had this all resolved in 2012. So
But
That's-
2012,
that's
it was
part of the
adjusted to 40-foot setback, right? Am I correct? 2012, it was a 40-foot setback?
no, 2009, Tom
2009.
Lane reduced it to the 40-foot setback,
Okay.
part of it, to allow the driveway, which was built within the 50-foot easement, conservation easement. So I understand what you're saying, but I think there's facts and circumstances here that you have to have some sympathy for the Randys who buy a property, as Mr. Florio said, they didn't buy a property with a 15-foot backyard. They bought a property with a 65-foot backyard. And now they're being told they can't use any of it. So after the town signed off on it, I just asked you how you would feel if that happened to you. And
I would have had a survey before I bought the property. So
Okay.
that's me.
I say something? Ed?
Wait,
Sure, Andy.
I have my hand up, so I'm gonna ask a
Okay.
question again. Now, Ed, you had said that you could pull something together that would be very specific.
Yes.
One of the things that I'd like you to show us again is the property map where the rock wall is, not, with the drawing, not the actual photographs. If you could show us that again.
Sure.
The reason I'm asking is, if I were to feel like I could live with this, I would want to have the deed restriction be from the rock wall back. Okay. I think, and the reason for that is what I remember seeing when you showed that was that the buffer area went right up to the marking of the wetland. Okay, and maybe even crossed into it some when you had the 10-foot from the rock wall. Now that's why so I am not comfortable with going 10 feet past the rock wall. Because on that drawing, yes, that's the right one.
Yeah.
Yeah, because for example, if I look at this, you know, in this area right in here, okay, you're going into the wetland area.
Oh.
Okay, so I would feel much more comfortable if you would just do it with this line here. Okay, and keep as much of the easement as possible. I don't believe that prevents them from using the backyard. I would absolutely want you to write up a very specific set of conditions for this that we would share with our town attorney, and make sure that this looks very specific, very site specific, and you know, allow us some option of supporting the you know, the property owners, while at the same time not abandoning what is a very critical thing, is ensuring those wetlands are protected. You know, like I said in the beginning, this was very contentious putting this in the first place. Okay, we had, you know, knockdown, drag out fights in those public hearings. I mean, I almost feel like this should go to a public hearing to be changed, but I'm not proposing that because I don't believe the law's on my side in that case. It's just, I remember how contentious this was. So those are the things that I would ask you to consider. I'm hoping that I'm not being unreasonable. I mean, I may be, but I'm hoping I'm not. But that's where I'm coming from, what I'm thinking about. And I would ask you to consider those options and see if we can get something that would work out of that.
Okay.
If I'm off base, you can certainly tell me. You know, I'm not.
No, I understand exactly what you're asking for. So I can certainly discuss that with my clients and, you know, report back.
And I'll be very honest with you. When I first read everything, I am extremely hesitant to make any changes to it. So you know, but I don't want to be disrespectful of a property owner who is trying to make fair use of their property. Okay, so I understand that give and take. I absolutely do. Okay, Eddie, I'm sorry I have held you back a long time. You're on mute, Eddie.
Still mute.
Eddie, you're still on mute. I'm sorry. I think what you said was very admirable. It was very, very good and generous. My only concern is with the new permissions from the land trust, Red Wing. Can't you use that? And that will give him enough property, and I'm sure he's going to use salt water and everything. It won't go past. It'll just take the new buffer line, you know, up to that, and what Red Wing gave him. Because what you said is good. It's just a few more feet, and then he'll have a full backyard, and I think it'll be easier on everybody. And then he won't be inside the wetlands. He'll be a little bit by the buffer, like what we did up at Big Y. We came within like 10 feet, but I'm just saying, if we could do something like that, but with permission, we already have the permission from Red Wing, the conservation people.
Right. And town council and wetlands will still have to approve it.
Yes.
Who does?
Town council and
I found that town council has nothing to do with planning and zoning.
They're one of the parties of the original agreement. They have to agree to it.
Okay. All right.
So,
But if
but
we- if
we
we-
make a recommendation.
Okay, well, if we can come up with what you just said and add in what Red Wing gave them, I think it'll be good. And Ed has to come up with exact plans for the pool. So we know
Well, I don't
exactly
care
what
where
we're
the
voting.
pool is as long as the language is property
The
specific.
language is, as I'm saying, the language will be properly, drawn up by Ed Casella and his clients. And that'll make the people comfortable, because we already have the conservation people on board. So if we get the people on this commission on board, we'll have a good thing. And I agree with what Alan said. Tom Lane, shouldn't have made some of those decisions, but a lot of people don't know that title searches and easements and everything. When they buy a house from a realtor, they hire a title search and do everything. They don't know all this, and they didn't know there was all corruption, like Mr. Florio explained to us.
Eddie.
That's all I have to say. I appreciate your time.
Adam, did you have your hand up?
Well, if there were other people, they were ahead of me.
I think
Okay,
I wanted to say something, if that's all right with the council.
go ahead.
I just want to fill in the gaps. I don't want to infuse too much. I mean, we said a lot tonight, but in regards to Tom Lane, I just want to bring up a couple of points. I spoke with Tom Lane in detail in regards to what was going on. I mean, that's the reason why I hired an attorney. I hired an engineer, Greg Fettis, and as well as I hired a surveyor. All right. That was because the town, both Tom Lane and Willie Fritz, said, in order to rectify this, what are we going to do? And that was the crutch of where I went on. That was, it's a word or a term that you use, detrimental reliance in the legal issue. They told me what I had to do. I actually did what they told me they wanted done. And I did that with clarity. It was very clear from Tom Lane and Willie Fritz that the town made a mistake, and to go forward with this, draw the new lines, hire the engineer. They even recommended Greg Fettis to me because he originally was involved in this area somewhat. So that was my point of view and why I went forward. I didn't go forward with this and draw new maps and so forth because I just thought I should. I was told by the town to do this. And that's what I was told. And that's what I did to rectify this issue with Tom Lane, as well as the town. And with him being a representative of the town, there's other documents that I have that stated that he made multiple decisions, not only changing the conservation line from 50 to 40 on this property, but other ones that he made allow a pool into conservation land. I mean, this was done by him, and it's on the town.
That's not really applicable to this situation. So I'm going to cut you off on that. I mean, he's not here to defend himself. I think it isn't going to impact your property. So let's just not go there. Okay.
All right. I'm just clarifying the record of what decisions were made and what he can't make that was brought up by the council. And I'm just clarifying that and making it simple that that wasn't true, because he did make decisions on his own, and it's town records. That's all.
Thank you.
Okay. Well, I think we've given you an assignment, Ed.
You got it.
Is there any more discussion for this evening?
I just have I have a question.
Go ahead, Jay.
So if we vote to proceed, then he still has to go to Wetlands Commission and another approval?
Yeah, the order of operations would be if the substance and get, things move forward with the Planning and Zoning Commission, the third party to modify the conservation easement is town council, because they were a party to that original 2002. So that puts the Red Wing Foundation, Planning and Zoning, and town council, all of whom signed that original piece. So that goes back to the very beginning of when the land was restricted. And that's step one. And then if all those get done, recorded on the land records, then they would have the rights to apply for the pool in the location that they showed as that proposed location with the Inland Wetlands Commission.
Okay, I'm just curious. Thank you.
Zach.
I just like to clarify with what you spoke about and bringing the line back to the original rock wall, the 40-foot easement that was approved in 2009, I believe. That permits what the seller originally bought
Correct.
on site.
It actually ends up only being a 10-foot easement in places.
But
in
that's
that
what
case.
but the seller presumed that's what he was purchasing
Correct.
is under the, okay.
I think it's important to know that on the 2009 plan, the 40-foot was in the vicinity of the driveway, but didn't necessarily extend all the way back into the rear yard area. And Ed, you can certainly jump in if you think I'm reading this wrong, but it was at certain points, but not along the entire length of the easement. So it wouldn't necessarily change what was in the backyard, or just in the side yard.
Yeah, that's correct. The 40-foot was to correct the driveway problem. The 10-foot easement was to correct the backyard problem.
Thank you. Unless there's a major point that I'm missing, I think that we can move on from this discussion tonight. Ed, you know what you need to do. Again, I would like you to coordinate with Abby, and so she can bring in the town attorney to look at whatever you prepare.
Understood.
Okay. That good enough? We'll move on to the next item then.
Thank you.
Thank you.
Thank you.
The next item is correspondence. We had a letter from Marianne Martinez, and I see that Marianne is here.
Yes.
Did you want to address the commission?
Well, what I would like to say is I did submit a memo or a letter to the town council and to planning and zoning. And my primary issue is following the regulations. So I have been told, and I outlined it, I won't repeat it, by people in land use office that there are regulations that cannot be enforced. I live in a house that was zoned as a single family. I assumed other houses around me on both sides were also zoned as single family. I have confirmed that. They are not being used. One is not being used as a single family. Once I have more time and receive a response from planning and zoning and the town council, I will be meeting with my attorney to draft a response.
Okay, thank you.
I wrote a
Kathy?
memo back. If you may, I'd like to read it.
I have not received a copy of it, and out of courtesy, I would think that I would receive a copy before it's being presented to planning and zoning.
That's fine. I'd like to read this to the commission in response to what you wrote. I can send you a copy. They received theirs today. Be happy to send it to you.
Well, since it's regarding something that I wrote to planning and zoning, courtesy would dictate that I receive a copy.
I agree with you, Mrs. Martinez, and I will be happy to send you a copy.
It's Dr. Martinez, actually.
I think that this is probably a matter for it's the discretion of the chair, what information is presented this evening.
Yeah,
So I maybe defer.
I believe that there's no reason to read this tonight. We will take our time, read your response, and allow Dr. Martinez to give her response to what you prepare, Kathy. Okay.
Thank you. I appreciate it.
Okay. With that, we move to adjournment.
Motion to adjourn.
Adjourn.
Okay.
It was a good meeting, Mr.
Okay.
Chairman.
All in favor?
I like to,
Aye.
aye.
Right.
Opposed? Abstaining? Motion carries. Thank you, everyone.
Good night.
Good night.
Have a good night.